Ladies and gentlemen, welcome to the conference, Reflections on the Legacy of Nuremberg, the 70th anniversary of the Nuremberg trials. My name is Ken Bamberger. I'm a professor here at the law school and the faculty director of the Berkeley Institute for Jewish Law and Israel Studies, and this year the co-chair of the Center for Jewish Studies. And those two organizations, the Berkeley Institute and the Center for Jewish Studies, are the co-organizers of this conference, which is funded generously by the Joseph and Ida Pell Endowed Fund for Jewish Studies. And to the Pell family, we are very grateful. I want to mention also the co-sponsors of this event because it really has been a campus-wide collaboration. And they include the Department of History, the Law School, the Magnus Collection of Jewish Art and Life, the Jewish Student Union, ICES, the Institute of Slavic, Eastern European, and Eurasian Studies, the Human Rights Center, the Berkeley Human Rights Program, the Center for German and European Studies at IES, the Institute for International Studies, and the State Bar of California International Law Section, which brings to mind that if you are a lawyer in this room and you would like to get MCLE credit, at the beginning and end of every session, and every session is qualified for MCLE, you need to go fill out the form at the back of the room certifying that you were here at the beginning and here at the end. And you have to do that for each of the sessions to get the credits for each session. And that also includes the keynote address this evening. Before I turn things over, I want to say we had a great start to the conference last night watching the film of the Nuremberg trials and the evidence presented itself. And today we have such extraordinary scholars joining us from not just around the country, but around the world. You'll each get your own welcome, but I want to say how appreciative I am that you were able and willing to take the time to come to Berkeley and join us for this event. And lastly, I want to give a big set of thanks and appreciation to the folks who have worked so hard on this conference. Andrei Dubinsky, Maya Shemtov, Leah Wagner-Edelstein, all from the Berkeley Institute, Etta Heber, the executive director of the Center for Jewish Studies, and finally, Rebecca Goldbert, the executive director of the Berkeley Institute, who really took this idea and sewed together an extraordinary lineup and an extraordinary flow and really curated what have already been phenomenal dialogues around this issue. So please give a round of applause to them. And now I'm privileged to call up in my place, and my work is done, Professor John Efron, our Koret professor of Jewish history at UC Berkeley. And the idea for this conference comes from John. 14 or 15 months ago, he had a chidush, he had an insight, and turned to me and said, you know, this is really something that's worth noting and something that we can do in a profound way and bring together many folks on campus. And to see this all come together 14 months later is really wonderful. So please welcome Professor John Efron.
Thank you. Good morning, everyone. I won't repeat what Ken said about our hosts and our co-sponsors. Although I will point out, every year we have the Joseph and Ida Pell Lecture in the history of the Holocaust, and in lieu of a single speaker this year, what we have here is this wonderful conference. And we're deeply indebted and filled with gratitude to the Pells for making this and all the other events that have been over the previous, I don't know, probably 10 years or so possible, thanks to their generosity. What I will say without repeating what Ken said is that many years ago, more than I care to remember, I was did my graduate work at Columbia. And I found myself one day, as one does, in the men's room, and with one of the great historians that Michael Marrus knows, because he co-wrote a book with Robert Paxton. And as I'm standing there, Paxton said to me, John, some of history's great deals have been conducted in men's bathrooms. So I do want to, and he was right, but I do want to add one more venue. And that is when I approached Ken to do this, this conference, I was in the Dwinell parking lot. And I said to Ken, we should do this. And Ken immediately said, yeah, sure, great idea, let's do it. Which is very different. I guess it's because Ken's in the law school. It's very different from the way things are done in the humanities and social sciences because, you've got to get a committee together. You have to write umpteen reports. That has to be sent to a subcommittee. And then it goes on and on and on. And then after about 14 or 15 months, then you're ready to sort of do a proposal and things like that. But I guess in the law school, they do things a little more quickly. And I was very, very grateful that Ken immediately said yes, and that allowed us to get the ball rolling and have this done in time. It may not have been for the 70th anniversary if it were done with someone else. So I'm very grateful to Ken for all of the assistance, and especially to Rebecca for the enormous amount of work that she's put into to bringing us here to today. So with that, I'm going to turn it over to Rebecca, and she's going to introduce the first moderator and then the first panel, and we'll get underway. And thank you very much once again for coming and joining us.
Good morning, everyone. I'm just going to welcome up our first panel, which is entitled Nuremberg as Legal and Historical Precedent. So Andrea Sinn is our moderator, Michael Bazler, Michael Marrus. Andrea Sinn will introduce our speakers, and I'm just going to introduce our moderators. So I'm going to begin with introducing Andrea Sinn, who is the DAAD Professor for German and History at UC Berkeley. She received her PhD from Munich University and taught as a postdoctoral fellow at the Department for Jewish History and Culture at Munich University. She's also curated 2 exhibitions for the Jewish Cultural Museum in Augsburg, Swabia, Germany. And her research and teaching focus on modern European history with specialties in German, Jewish, and migration history. She is currently also working on a project entitled Joining the German Home Front, Jewish Women and the First World War, inspired by her apparent absence of female and minority perspectives in studies addressing World War I. And she's also worked significantly on World War II and post-war German Jewish history and society as well. So please welcome her up, and she's going to introduce our panelists. Thank you.
Well, good morning, and welcome to our first panel of the day entitled Nuremberg as Legal and Historical Precedent. I have to say I'm very delighted to be here and to see so many of you here this morning. Many of you joined us already yesterday for the screening of Nuremberg, its lesson for today, that was followed by a Q&A session with filmmaker and producer Sandra Schulberg and my colleagues Professor Saria Mohammed and Richard Buxbaum. I was particularly impressed with the powerful arrangement of the in large parts unknown film material, and as someone who was raised in Germany and received her high school and university education there, I was particularly fascinated by Sandra Schulberg's concluding remarks in which she described her experiences in connection with the post-war screening of this film in various different national and international contexts. Thanks again for sharing that with us yesterday. I'm looking forward to continuing the conversations that we started last night today, and therefore, without further ado, I am very honored to introduce our distinguished speakers of this morning, Professor Michael Marrus and Professor Michael Bazler. Both of my colleagues don't need much of an introduction, but I would like to take a moment before each of their presentations to remind you of their great contributions pertaining to our conference theme. We will have time for all of your questions at the end after both of their presentations of this panel. So let me begin with our first speaker, Professor Michael Marrus. Professor Marrus, a leading Holocaust historian, is the Chancellor Rose and Ray Wolf Professor Emeritus of Holocaust Studies at the University of Toronto and a Fellow of the Royal Society of Canada. In fact, he's also a UC Berkeley alumni who received both his MA and his PhD at this institution in the 1960s. His research focuses on the Holocaust, international human rights, and the relationship between law and history. His many publications underline his experience and expertise in these and other fields. He's the author of 6 books. Among them are Vichy, France, and the Jews, that he co-wrote with Robert Paxton, that was mentioned, The Unwanted European Refugees in the 20th Century, a topic of great importance once again, The Holocaust in History, and in our context, the most relevant, the Nuremberg War Crimes Trial, 1945-46, a documentary history. Spanning the years from 1919 through 1964, his work provides students and scholars of the Second World War and international law with a fascinating documentary account of the most infamous war crimes trial of the 20th century. Until today, Michael Marrus has been, among others, a visiting fellow of St. Antony's College in Oxford, at the Institute for Advanced Studies of the Hebrew University in Jerusalem, and a visiting professor at UCLA and the University of Cape Town. He's presently writing a book seeking lessons of the Holocaust to be published by the University of Toronto Press. I'm sure we can all be looking forward to this study that is part personal memoir and part analysis of the idea of lessons of the Holocaust. We're also very much looking forward to your presentation here today that will direct our attention to Nuremberg's Forgotten Origins, International Humanitarian Law. Let's give a warm welcome to Michael Marrus.
Andrea, thank you so much. Ladies and gentlemen, good friends, it's a convention to begin one's talk at a conference by thanking organizers for inviting, in this case, me. But I, having hoped that you accept this and I've discharged that responsibility, I want to widen the message with regard to this particular conference, because I find myself with colleagues and friends with whom I've worked for a good many years, and I have to tell you that we so much have enjoyed speaking together amongst ourselves, comparing notes, and doing all those things which one does not do when one sends one's papers via email. We actually engage. And so I dare not mention individual names, since I see how many have worked together to bring this event to pass, but I want you to know that we not only appreciate the theme of this conference and its commemorative purpose, but we extraordinarily enjoy being here together in Berkeley. And now I hope the clock can start. Ladies and gentlemen, anniversaries. Anniversaries are a time for generous reflection, particularly for the commemoration of achievements that are considered a good thing, and I think we agree that Nuremberg was such, particularly for such achievements. Celebrants generally seek that no antecedent be left unappreciated, no precursor be unacknowledged, and that the widest possible recognition be made of significant contributions to the happy event. This is part of the reason why, as we commemorate Nuremberg at this meeting, I want to inject some reflections about its background in international humanitarian law, which I'll refer to as IHL, a theme which I think has been largely ignored in the various anniversary gatherings that I have attended, as well as in considerable writing on the subject, including, I might add, my own. So here are a few thoughts about how Nuremberg should be seen, in part at least, in the context of the evolution of international humanitarian law. My argument will be that IHL was important for helping to secure both the legal foundation and the legitimacy of the International Military Tribunal at Nuremberg. But before proceeding, let me begin by situating, with apologies for the summary form, the modern history of IHL. Note that I am not speaking of human rights law, notwithstanding the commitment of both to the cause of human dignity. International humanitarian law has perhaps been most succinctly defined by the International Committee of the Red Cross, its official oversight organization, as a set of rules which seek, for humanitarian reasons, to limit the effects of armed conflict. It protects persons who are not or are no longer participating in the hostilities and restricts the means and methods of warfare. My own account of the modern beginnings of IHL gets to work in the middle of the 19th century in what the English historian Asa Briggs aptly calls the Age of Improvement. And it does so with two quite separate historical initiatives, each of them embodying a particular spirit of the age. The first of these, an account of the horrific Battle of Solferino in 1859 in the Wars of Italian Unification, was published in 1862 by Henri Dunant, an eccentric Swiss humanitarian, and gave rise to the first of two streams of IHL, what is known as Geneva law, treating military and also civilian victims of war, and the second, an operational manual authored a year later by Francis Lieber, a German-American academic and jurist with close ties to the administration of Abraham Lincoln, that generated Hague law, treating the conduct of war on the battlefield. Less than a decade after the appearance of these two works, the brutalities of the Franco-Prussian War, 1870 to 71, shook Europeans, both by the scale of the casualties among Europe's foremost military powers, and also by the advent of guerrilla warfare fought against the Prussians by the French francs-tireurs. Now, how did these two paths, almost a century before Nuremberg, paths that essentially blurred and periodically overlapped, how did these two paths eventually connect with Nuremberg? This is a story that I think needs to be added to the conventional accounts of the origins of the International Military Tribunal, and it's what I want to talk to you about this morning. Crucial to the tale are the beginnings of the study of modern international law, the juridical and conceptual landscape on which both of these streams rested, and which may be traced precisely to this period. Modern international law emerged with the political ascendancy of liberalism in the late 19th century, writes the distinguished Finnish jurist Martti Koskiniemi. By the end of the century, the profession had been organized. University chairs of international law had been created all over Europe. Thick, many-volumed textbooks and international law journals started to appear in several languages. The Hague Peace Conferences of 1899 and 1907 inaugurated the era of international legislation as part of mass politics of industrial societies. Terminologically, all of this involved a great deal of rumination on the laws and customs of war. And this term echoed widely at Nuremberg and indeed found pride of place in Article 6 of the Charter of the Nuremberg Tribunal defining war crimes and in the judgment of the tribunal in 1946. World War II, however, brought something new, and this is what my friend Devin Pendas, who we'll hear later in the day, writes about. He calls it the legalist paradigm of war. Devin Pendas is one of the few to take up this link between IHL and Nuremberg in a serious way, and he argues learnedly and persuasively to me, and I hope eventually to you as well, that beginning in the fall of 1943, this legalist paradigm of war emerged as a new approach. The Allies declared their intention to pursue a legal as well as a political and military strategy for managing the end of the war, he writes. Now, while not disagreeing with this, indeed, while agreeing with almost everything he says about the matter, I do think that this account could use a bit of historical fine-tuning. The half-century preceding Nuremberg was not simply a free range for blinkered thought and ethno-cultural fantasizing, as many authors propose. Nor, it turns out, given that Nuremberg was in the offing, were the humanitarians of the day living in a dream world. Rather, despite its admitted failures, the development of IHL should be seen as part of a slow maturation of humanitarian sensibilities and legal thinking since the mid-19th century. That is why the Nuremberg court made specific reference to the Hague Conference of 1907, for example, in its codification of the rules of war on land. That's the Hague Conference's codification of the rules of war on land. That convention of 1907 expressly stated that it was an attempt to revise the general laws and customs of war, that's the phrase again, which it thus recognized to be then existing, and by 1939, these rules laid down in the convention of 1907, the laws and customs of war which are referred to in Article 6 of the Nuremberg Charter, the section having to do with war crimes. Most important, I'm suggesting that along with the thirst for justice in 1945, exemplified in Nuremberg, was a quest for a more humane world, a world in which the laws and customs of war would solidify a universal recognition and respect, a world in which there were, as champions of IHL had always insisted, limits to the license to kill and maim that war accorded to the combatants of modern warfare. This is the side of Nuremberg on which I want to concentrate in my talk, even while acknowledging that this was indeed part and not all of the story. One of the main themes of the 19th century beginnings of IHL became central to the Nuremberg script. The idea that the court was operating on behalf of all of humanity in defense of civilization, and not just in the service of those victorious powers who constituted the International Military Tribunal. Those of us who saw the film yesterday evening may perhaps remember the American Chief Prosecutor Robert Jackson saying precisely this. He couldn't have made the point clearer when he told the judges, "The real complaining party at your bar is civilization." Let us pause to acknowledge what a leap of idealism was involved in this claim. And let us note as well one of the great ironies in tracing links to the earlier champions of international humanitarian law. I say ironic because these aspirations were first articulated in the 1860s by no less a pair of visionaries than the two rulers of the Russian Empire, the jailer of nations. First, Tsar Alexander II, and later Nicholas II, emperor and autocrat of all the Russias, the last ruler of the Romanov dynasty. These were the two moving statesmen behind IHL in the 19th century. Imagine that. Among other things, this is a reminder that we are speaking about an imperfect world. Of course, we need to acknowledge that the great humanitarian campaign to stigmatize the infliction of unnecessary suffering in war had mixed motives. Some of these had to do with checking the arms race, limiting the arms race among the great powers. Some had to do with international prestige, and some had even to do with promoting the values of imperialism. That is another story. But that said, and notwithstanding the blinkered and constricted notions of humanity among our originators of IHL, and they were limited by comparison with our own, still, the proponents of humanitarianism showed remarkable idealism, energy, resolve, and on paper at least, some success. I'm speaking of a chain of meetings, assemblies, conventions, agreements, assembled at places like The Hague, Geneva, Brussels, St. Petersburg, and elsewhere. This is all in the second half of the 19th century, where international experts crafted documents and treaties and agreements intended to serve what they understood to be the cause of humanity. A final link, if I may, to Nuremberg. A close student of the origins of the International Military Tribunal, Professor John Barrett, the biographer of Robert Jackson, makes the case that even before the First World War, the work that I have described and its dissemination had something of a galvanic effect on many Americans. Those are his words. Nuremberg and its sequel were steeped in the rhetoric and the idealistic idiom of international humanitarian law. Barrett mentions 4 men, not quite randomly, I admit, 4 men who were so galvanized. One was a New Jersey professor of government, Woodrow Wilson. Another was a young lawyer, world traveler, and close student of President Theodore Roosevelt, who indeed emulated him in many ways. That's Frank Roosevelt of Manhattan and Hyde Park, New York. A third, located in Frewsburg, New York, was a 15-year-old high school junior, a voracious newspaper reader, and an interscholastic debater of policy issues such as these, and that's Robert Jackson. And a fourth, another high achiever, was a young Missouri student whose talents and efforts would take him to war and business failure and machine politics, and ultimately to some greater successes. I'm speaking of Harry Truman. All of them were caught up in the wave of idealism and excitement and creativity of international humanitarian law. The next point I would like to make takes us back to the legalist paradigm of war, what Devin Pendus notes as thinking about the conduct of war as a potentially criminal enterprise, one that ought to be legally actionable in some manner. With thoughts such as these, we are clearly in the territory of Nuremberg, the kind of proceeding which, as Cordell Hull and Henry Stimson and James Forrestal put it in a memo to Roosevelt in 1944, there would be a proceeding that will be judicial rather than political, resting on established legal concepts. Now, my contention here is that those who thought about these matters had a single unifying belief in the existence of something called the laws and customs of war, a concept and a terminology that was distinctly that of IHL, used both to legitimate contentions about precedents and also to specify the character of German wrongdoing. Thanks to the work of this founding generation from the time of Durand and Lieber, the laws and customs of war did not have to be teased out of the pages of Grotius and Vattel or others from the early modern era and before. For one of the achievements of the foundation era of the IMT was precisely the codification of these legal antecedents and their incorporation into professional legal understanding. Statesmen applied such thinking to the practice of international law. In the United States, where so much of the heavy lifting took place in the planning of the IMT trial, the laws and customs of war were core preoccupations of two presidential administrations long before Nuremberg was ever dreamed of. I'm speaking of the presidencies of Woodrow Wilson and Franklin Roosevelt. And the reason for these preoccupations had actually very little to do with war crimes in general, or for that matter, of crimes against humanity. The issue was German aggression and related to the mayhem on the high seas, and the problem was how to preserve American neutrality even while supporting the struggle against the Germans. You see, we are far here from Nuremberg, but watch as we get closer. Woodrow Wilson worried long and hard about these issues, as did experts in the Roosevelt administration beginning in 1939. And among these experts was Robert Jackson, who worked particularly on issues of American neutrality when he helped secure the transfer of aged destroyers to the British in the early days of the war. And one of his main themes in doing so was the identification of what he was later to call the crime of crimes, and this was the theme of last night's film, the crime of crimes, which was for Americans the linchpin of the criminality of the Hitler regime, its recourse to aggression. Other countries, Jackson insisted, had the right, if not the duty, to vindicate the rule established under these treaties by assisting the victims of unlawful aggression. And that was the core and central idea with which Jackson and others argued for an international military tribunal. A few words now about national sovereignty, held in the literature to be the great obstacle to the universal cause of human dignity. I'm not so sure. General histories of Nuremberg make much of the fiasco of the Allies' decision in 1919 to direct the German Supreme Court at Leipzig to try Germans accused of war crimes, their objection was largely due to American objections that an international trial, such as favored by the British, would be a violation of the principle of national sovereignty. In 1919, America, international criminal justice came down very, very lightly indeed, light as a feather. And so it was to the Germans to try German war criminals a celebration of the principle of national sovereignty. But the results were derisory, as is well known. Originally, the Allies proposed that the Germans deal with nearly 900 accused war criminals. The Germans agreed to try 45, and only 12 were ever brought to court, and only 6 were convicted. And of these, 1 was immediately released, while the others received very light sentences. And finally, one of those convicted, several managed to escape from their German prisons. This was, critics have said ever since, this is what you get when you rely on national sovereignty. The conventional view. And Nuremberg, so the story goes, took on this challenge and therefore broke radically with the idea that had hobbled international humanitarian law. The 19th century did not crack the hard nut of state sovereignty, it is said, of which this era was the great heyday. Nuremberg's great reputation stands high, again, so the story goes, because whatever its procedural shortcomings, its thrust is seen to be in reversing this disposition of national sovereignty, opening the way for the discharge of genuinely international justice. Now, I have some trouble with this argument, and for 2 reasons. First, many of the achievements of pre-Nuremberg IHL are rooted in the realities of the sovereign authority of the nation-state. I note that each of the 2 great 19th century initiatives, Dunant's and Lieber's, were rooted in appeals to states, not against states. Indeed, my point would be that states played a central role in both initiatives, Geneva Law and Hague Law. Indeed, the essential element in the early culture of international humanitarian law was state sponsorship, state legitimacy, and ultimately state oversight. Nothing would have transpired without national government decision-making, rules approved and crafted by national armies, with agreements signed on the dotted lines by responsible authorities, and even proclaimed to the world by the Tsar of all the Russias, a partisan of state sovereignty if ever there was one. I also have trouble with the notion that Nuremberg fatally undermined the paradigm of state sovereignty by opening the door to some sort of universal jurisdiction over a new level of criminality, namely state-sponsored war crimes and crimes against humanity. Nothing could have been further from the minds of Nuremberg planners than the idea that they were undermining the foundations of the sovereignty of their respective states or yielding authority to their wartime allies. I defy anyone to examine the records of the June Conference 1945 of the American, British, and French and Soviet jurists assembled in London to prepare the Nuremberg Charter and show me any disposition on the part of the participants to limit or disparage or diminish or challenge or weaken the sovereignty of the prosecutorial powers. To be sure, Nuremberg's present-day public associations are much less with international humanitarian law than they are with other themes. Like justice, for example, or crimes against humanity. But historians rightly caution us against anachronism. While appreciating that legacies shift, the former was a championed alternative to the much more popular and grisly option. This was the option of most people in 1945, swift execution of German war criminals after summary proceedings. And the second largely an afterthought to deal with German atrocities that were not war crimes and mainly concerned German citizens. That's international, that is crimes against humanity. So I have tried in my talk, which now nears its close, it is at its close, I have tried to resurrect an older antecedent older than the specific events of 1945, older than the hopes that there might not be a Cold War and that the world could be presided over by the Big Four, as they were called. I have tried to resurrect an older precedent along with so many of the other specific problems and issues of 1945, and to identify international humanitarian law as an element that we need to consider when we look at the long-term origins of the events that we are commemorating today. Thank you very much.
Thank you so much for getting us started and making my job one of the easiest, not having to do a whole lot in regard to any time restrictions we might want to keep in consideration. I'm very happy to introduce our second speaker of today. At this point, Professor Michael Bazler, who is since 2008 the 1939 Club Law Scholar in Holocaust and Human Rights Studies at Chapman University School of Law in Orange, California. Michael Bazler is also a research fellow of the Holocaust Education Trust in London and the holder of previous fellowships at Harvard Law School and the United States Holocaust Memorial Museum in Washington, D.C., and a research fellow at Yad Vashem in Jerusalem. Michael Bazler also received his education in California at UCLA and the University of Southern California Law School, and is today a leading authority on the use of American and European courts to redress genocide and other historical wrongs. He's the author of over a dozen law review articles on subjects concerning public international law, international human rights law, international trade law, and comparative law. In addition, he published an impressive number of books on the topic, as, for example, Holocaust Justice, The Battle for Restitution in America's Courts, was a contributor of chapters to various books on genocide and the law, and the co-editor with Roger Alford of Holocaust Restitution, Perspectives on the Litigation and Its Legacy. His latest co-authored study, entitled Forgotten Trials of the Holocaust, was published last year by New York University Press. This book uncovers 10 forgotten trials of the Holocaust, selected from the many Nazi trials that have taken place over the course of the last 7 decades. Instead of focusing on the well-known Nuremberg trial and the Eichmann trial, his study showcases how perpetrators of the Holocaust were dealt with in courtrooms around the world, in the former Soviet Union, the United Kingdom, Israel, France, Poland, the United States, and Germany, revealing how different legal systems responded to the horrors of the Holocaust. Today, he will take us back to some questions we broached in our discussion yesterday evening and talk about the Nuremberg trials and the birth of modern international law. Please give a big applause to our next guest, Michael Bazler. We'll take a moment to also figure out technical details, but be assured we are about to continue in just a moment.
No, I'll use This is a pointer. Oh, perfect. Okay. Thank you so much. I'm so glad to be here. When Rebecca Goldberg contacted me and said that they're putting together a conference on Nuremberg, I thought wonderful, because I was planning also some events to commemorate the 70th anniversary. And I have to say that the foresight of UC Berkeley, you are the first ones in 2015 to commemorate the 70th anniversary of the Nuremberg trial. So kudos to those that had the foresight in the bathrooms to make that decision and decided this is the place to do so, and taking the idea and putting it together. I have to say that when Rebecca called me and she mentioned that Michael Marrus is coming, I said, absolutely, I'm going to be here. And then she gave me the additional treat of being on the same panel with Michael. So I thought what I would do is sort of with this, my brief introduction, is to, not related specifically to this, is to, for those of you, that are academics, you know how proud you are of the various publications that you have and the books and articles. But what we're most proud of are our students. It's like parents that are proud of the children. So what I want to do is start off with Michael Marrus's children. Oh my God. So much we have benefited over the years, so much from Michael's writings. But I think his most significant contribution is teaching so many generations of students. So I want to introduce you. On top is Thomas Jargin, who teaches at Ryerson University, and all these Ryerson, and who in Toronto, Canada, who and all of these professors have written in the area of trials. So whose book on the Mauthausen trial, American Military Justice in Germany, was published by Harvard University Press in 2012. And Thomas is now working on a second book on the trial of Ilse Koch, the notorious wife of the commandant at Buchenwald. Next to her also on the top level is Rebecca Whitman, who teaches at University of Toronto, who wrote a book on the Auschwitz trial, Beyond Justice, by Harvard University Press, published in 2005. And she's now working on another book on the Majdanek trial. And down below Thomas is Valerie Hebert, who teaches at Lakehead University, who wrote Hitler's Generals on Trial, the Last War Crimes Trial Tribunal at Nuremberg, published by University of Kansas in 2010. And last, we have Hilary Earle, who teaches at Nipissing University, if I'm pronouncing it correctly, also in Canada, and who wrote the Nuremberg SS Einsatzgruppen Trial 1945-1958, published by Cambridge University Press. And you can see how much we benefit from all this. So this is not a first shrift and Michael's dedication, but I thought I'm going to do this as a personal gratitude to him on behalf of all of us for doing that.
Thank you so much.
So I want to begin taking you back 10 years ago in November 2005, when the American Bar Association held a conference in Washington, D.C. on the same subject, commemorate the 60th anniversary of the trial. And the ABA at the time gave the conference an intriguing title. The title is Nuremberg and the Birth of International Law. And according to the organizers, the title was chosen because the trials, and I quote now, the Nazi war criminals by the Allied countries at the end of World War II have had a profound impact on international jurisprudence. And in some ways, the term profound impact, I think, is an understatement. And a more accurate description would be that modern international law has had its birth, and all of international law, I think, its rebirth, in the aftermath of Nuremberg. And international legal scholars divide the development of international law today into two periods. One existing before Nuremberg, and the other, the current state of international human law, as it was shared by the law, both by the newly created and strengthened, as was in Nuremberg. The most important contribution to international law by Nuremberg was the recognition by the recognition of the international community of two crimes for which individuals could not be held personally responsible: genocide and crimes against humanity. And I want to discuss the origin of these two crimes, but before doing so, I want to go back and focus on what I would call judgment before Nuremberg. And this is the origins of the prosecutions. So as the war is going on in November 1943, the foreign ministers of the three countries get together in Moscow, and then they sign a declaration. It's the Moscow Declaration, and include that is a statement of atrocities that's signed by President Roosevelt, Prime Minister Churchill, and Premier Stalin. And I bolded for you the part that deals with what they plan to do when the war is over. So those German officers and men and members of the Nazi Party who have been responsible, have taken a consenting part in the above atrocities, will be sent back to the countries. Do you see that? Which their abominable deeds were done in order they may be judged and punished according to the laws of those countries. And then with regard to the Nazi leaders, we're going to decide this later on. That's the last paragraph. And so this is in November. In December, a month later, as the war is still going on, the Soviets put that into practice by holding a trial, and this is the very first Nazi war crimes trial. That's why I call it Judgment Before Nuremberg, in the Ukrainian city of Kharkov in 1943. And this basically, what they do is they now are going to take and what they said the month before and actually conduct a trial. And so on trial are 3 Germans and 1 Ukrainian that were tried before a military tribunal. You see how similar it is to Nuremberg, and you'll see a number of connections here. And this is a tribunal constituted by the 4th Ukrainian Front of the Red Army, composed of 3 military judges. There is a state prosecutor, there are 3 defense counsels, and to accommodate the large audience, to have the necessary gravitas of the trial, is they hold it in a dramatic theater. There's a theater-like atmosphere, because there's illumination of the auditorium with Klieg lights. They're filming the proceedings, and foreign correspondents are invited to watch the proceedings. And the most knowledgeable of the observers was an American journalist by the name of Edmund Stevens, who was a seasoned Soviet old hand. He married a Russian woman, and in 1945, he publishes a book called Russia is No Riddle, where he talks about the proceedings themselves. And he says the atmosphere at the Kharkov trial was distinctly reminiscent of the famous treason trials of 1936 and 1938. In fact, 2 of the defense lawyers had defended some of the figures in the treason trial. This, too, was a military tribunal. Judges, prosecutor, and attendants were all in uniform. And during the recess, he says, I discovered that many of the people in the audience had personal knowledge or experience in the events and atrocities described, and had seen or known the defendants during the actual occupation. So who were the defendants? They were characterized by Stevens as small fry, non-entities, and they were chosen to embody the various ranks of German military command that were occupied in the Kharkov region. And the 3 defendants are Wilhelm Langfeld. He's a 52-year-old captain of the German military counterespionage, and he was a commander of a POW camp for Soviet prisoners in the Kharkov region. And he's described by Stevens as a beefy-faced, whose carriage, heel-clicking, and rows of ribbons proclaimed a German soldier of the old school. It kind of reminded me of the defendant Keitel at the Nuremberg trial. The second was Hans Ritz, who was a second lieutenant in the SS, and Stevens described him as a Nazi horse of a different color from the hard-bitten Langfeld, a baby-faced youth of 24 with a tender mustache. Ritz was trained in music and law and actually worked as a lawyer before joining the SS and then sent to fight on the Eastern Front. The third German defendant was Reinhard Retzlaff, 36-year-old corporal, who was not even a member of the Nazi Party. And there was a fourth defendant who was a collaborator, a Russian, Ukrainian, who was 26-year-old and who worked with the Germans in the local occupation. The four defendants were charged under both international law and Soviet law, and the legal basis for the prosecution was the Moscow Declaration that I mentioned to you. The German defendants appeared in court dressed in full military attire, which was not common in Soviet trials, and after a public reading of the indictment, they all entered guilty pleas. But this was a continental legal system. It's also where the court, the Soviets wanted to have a trial. It was done for the international audience. So the trial continued with evidence, and detailed evidence of the brutal atrocities committed by the so-called fascist Hitlerite invaders were read out. And as confirmation of the fact that the Soviets wanted to publicize this trial was the fact that they translated the excerpts of the proceedings into English and put together in a book that's still available today, out of print, called The People's Verdict. And a movie was made of the trial. It was a documentary that was shown in Soviet theaters. It was supposed to play in the West, but never did. Stevens, the American correspondent, noted that, and I quote now, all legal niceties were observed to a fault. The defendants and their counsel had full latitude to speak or interpolate, and every comma, what was said, was translated into German for the benefit. Each of the defendants took the stand and was questioned by the prosecutor and by members of the tribunal and the defense counsel. Later on, Professor George Ginsburg, who wrote about the trial in the 1960s, states that there was no indication that the German defendants had either been rehearsed or coerced. The defense strategy was, and this again similar to Nuremberg, to blame everything on the higher-ups, that fulfilling of superior orders. And this is what you hear later in Nuremberg. On the morning of December 18th, 1943, after 3 days of this trial, the prosecutor gave his closing arguments, and interestingly enough, in the closing argument, he referred to the Leipzig trials, and he specifically mentioned the Landover Castle case, where in 1921, 2 German naval submarine officers were convicted of war crimes. So this was precedent for the fact that war crimes were punishable and that the defendants were aware that they would be punishable. The defense counsel did not argue with the prosecution's request for a guilty verdict, but they set out extenuating circumstances. So one of the defense counsel said, these men were made into assassins first of all killing their souls, and it is doubt which gives me, comrade judges, the moral right to pose the question of possibility of a lesser penalty that demanded by the prosecutor. And then the defendants were allowed to make their own statements. Ritz, the young lawyer, gave the most eloquent speech in an attempt to save his life. And he argued, like the other defendants, the defense of duress, but he asked as follows, this is his plea, I would like to ask the court to take into consideration an old principle of Roman law, crime under duress. You must believe me that if I had not obeyed orders, I should have been arraigned before a German military tribunal and sentenced to death. And he pleaded, when the Hitlerite system came to power, I was a child of only 13. From that time on, I was subjected to a systematic and methodical influence of the Hitlerite system and education in the spirit of the legend of the superiority of the German race. I realized that the destruction of the system would now be an act of justice. I am young. Life is only beginning with me. I request you to spare my life so that I may devote myself to the struggle against that system. Well, the tribunal judges returned with a verdict later that evening. It was around midnight. The lights in the final blaze of Krieg lights, and they found all the defendants obviously guilty, and they all were given death sentences, and the death sentences were carried out. So this was the very first trial of Nazi war criminals. Fast forward from December 1943 to August 1945 in London, where we have the London Agreement signed and the beginning of the trial of the International Military Tribunal in Nuremberg. Began in November 1945, ended in October 1946. Now, the crimes that were charged, and I want to focus on this, and as Michael pointed out, the easiest crime that the defendants could have been convicted of, and there was no problem about violating the principles of legality, and this was on the books, and there was precedent for it as war crimes. And so there was not a problem with that, and they all could have been convicted on the basis of violating the laws and customs of war. So we're not talking about the small fry now, but the 21 leading defendants on the dock in Nuremberg, the policymakers. And in fact, Hirsch Lauterbach, who I'll mention in a moment, at that time one of the most prominent professors of international law, wrote an article in 1942 where he talks about what will happen when there will be an armistice, there will be defeat of the Germans, and the only crime that he mentions during that time is war crimes, because there was so much precedent, there was treaty to that. But that was not the point. What the prosecutors wanted to do is to try the defendants with other crimes. And the others were crimes against peace, crimes against humanity, conspiracy, and one of the crimes that was talked about but not charged as particular a crime was genocide. And we'll talk about that in a moment. Now, this is just to show for those that were not here yesterday at the documentary, these are the defendants on the dock. These are the judges. Chief Prosecutor Robert Jackson. And this is the war crimes charge, namely violations of the laws and customs of war. And they could have been convicted of that. But Justice Jackson, the chief prosecutor, wanted to have another crime, and that was the crime of waging aggressive war or crimes against peace. And this is also known as the crime of aggression, and it was part of the indictment, it was part of the London Charter. And it defines it as planning, preparation, initiation, or waging of a war of aggression or a war in violation of international treaties. The idea of charging the leading Nazis with this crime was controversial at the time and has remained controversial to this day. But for the Americans, and I think as we saw this in a documentary, this was the crime that was the chief offense of the Nazis. And the criminality of aggressive war was needed to be enshrined in international law. But the problem was that starting a war had not been regarded as criminal up to that time. There was a treaty, the Kellogg-Briand Pact of 1928, which outlawed war, not successfully, obviously, but only rendered aggression an illegal act for states. It didn't talk about individual criminal responsibility as a criminal act. And the French resisted the concept for this reason. The Soviets, for their part, obviously because they were also aggressors during the war, were concerned about criminalizing this crime. The American view, however, prevailed, though the tribunal's jurisdiction was limited to the Axis aggression. It was not aggression of any other countries. And the definition of aggression was specific enough for prosecution of the government officials remain elusive. Now, they succeeded because in the Nuremberg judgment that was issued in October, the judgment itself says that the crime against peace is the supreme international crime, differing only from the other crimes in that it contains within itself the accumulated evil of the whole. So the prosecutors succeeded, specifically Justice Jackson, of making crime against peace as recognized as an important crime and the chief crime. Obviously, going forward has been a large failure. When you go to today and you look at the Rome Statute for the International Criminal Court, there is no crime of aggression specifically set out. There's references to it. If you look at the ICTY and the ICTR statutes, the Yugoslav and Rwandan Tribunal, there is no crime of aggression. None of it is relevant, but it's not something that is part of what we consider to be a body of international law and the prime crime which Jackson wanted to enshrine. Now, the other crime was crime against humanity. Now, this was what I would call a parasitic crime. It was the one, call it sort of the puny crime, the one that they had least confidence in. And the way it came out is that Jackson wanted to have a crime that he called atrocities, deportation, and execution. But during a dinner at Trinity College, and he was in touch with Professor Hirsch Lauterpacht, maybe he was in the bathroom, suggested to him that there's a better name for that crime, and that is crime against humanity. And look at the way it's written. It's namely murder, extermination, enslavement, deportation, and other inhumane acts committed against civilian population before or during the war. And then you see the semicolon. That's a very important semicolon. And then it says, or persecutions, and talks about persecution. So there's two categories here. There's the murder types of crimes of humanity before the semicolon, and then there's the persecution type after the semicolon. Now, if you look at the murder type, the way it's written, it's all kinds of murder, extermination, enslavement, both before and during the war. The Nazis came into power in 1933. World War II didn't start till 1939. The persecutions of the Jews began in 1933. So what about all those acts? Well, looking at the first phrase, it looks like it's covered by crimes against humanity. Do you see that? But the second phrase, persecutions on political, racial grounds, those have to be in connection with any crime within the jurisdiction of the tribunal. And that's very strange, because the crimes against humanity is already within the jurisdiction of the tribunal. So it's circular, right? But that's called the wartime nexus. Somehow, you can only charge the crimes against humanity if it's connected with one of the two other crimes. That's why I call it the parasitic crime. It's dependent on the other crimes. Well, later on, before they began the proceedings, they realized that there was a discrepancy between the English and the French text and the Russian text, because the Russian text didn't have that semicolon. The Russian text had a comma. Now, grammatically, notice how the comma changes it. Because then if you put the comma in there, then within the jurisdiction of tribunal now modifies the first category of crimes. And this was the way that the tribunal accepted it. All right, let me go back. I'll go forward to this. Okay, and this is comes from the judgment itself. Okay? With regard to crimes against humanity, there is no doubt whatever that political opponents were murdered in Germany before the war. The policy of persecution, repression, and murder of civilians before 1939. Okay? It talks about that. The tribunals have the opinion that revolting and horrible as many of these crimes were, it has not been satisfactorily proved they were done in execution or in connection with any such crimes. Do you see that? So it's the comma, all right? The tribunal, therefore, cannot make a general declaration that acts before 1939 were crimes against humanity within the meaning of the Charter, but everything after 1939 is a crime against humanity, okay? Now, people have argued, well, that's just jurisdictional, that what they meant is they didn't have jurisdictions above that. I think it's more than that. I think what they're basically saying, or could be saying, that they cannot, as a matter of law, not enough evidence would show to them, that what was done by the Germans prior to 1939 was proven to be a crime against humanity. And we still debate about this to today. But the verdict comes out, and it is a very disappointing day for this man, Raphael Lemkin, who coined the word genocide in 1944. In this book, Axis Rule in Occupied Europe, in chapter 9. And he invents the word. All right? Genocide, we mean the intentional destruction of a nation or ethnic group. Genus from the Greek tribe or race. Side from Latin killing. And he has a definition of what genocide should be. He's on the prosecution team, the American prosecution team, but he's tendential to it. But he tries to push the word genocide. But you can't make genocide a crime because it was not recognized as a crime. The most they could do was as crime against humanity. But it appears in the indictment, and genocide appears as a term during the trials by the various prosecutors, both in the main trial and the later trials. But when the verdict comes out with the language that I showed you, he later says that's the blackest day in his life. Now, why is he disappointed? One is that he learns at that time that most of his members of his family were murdered. His brother survived. And it's blackest because nowhere in the judgment is his precious word genocide mentioned anywhere. Okay? And second, you see that with regard to crimes against humanity, I mean, there's this nexus, it's this puny crime, and he's very disappointed. Now, the person who's, maybe less disappointed, Hirsch Lauterbach, who is a professor at Cambridge, one of the most distinguished professors of international law. Interestingly enough, both these individuals come from Galicia in Poland. Okay? The Galicianer Jews. Lauterbach was German-speaking, happened to be in the Austro-Hungarian part of Galicia, and Lemkin was, like me, on the Polish side of Galicia. But both of them went to the same law school involved in Lemberg. Lauterbach was first. He then ended up studying in Vienna and then ended up in England before the war started and already made his name. Lemkin fled during the war because he spent his pre-war years in Poland. And they end up then being these two contributors to the law that's made at Nuremberg. The judgment comes out. You see, this is a cartoon from that time, 1946. With the various defendants. This is the New York Times story from that time period. Right? But genocide itself, you see, is not mentioned. What happens afterwards is Lemkin goes and works very hard to try to make genocide a crime. You see here, this is his ID card to the General Assembly. And genocide does become a crime in 1948 and then ratified in 1951 and becomes now the crime of crimes. And that's the term that's used for genocide today. You then have, in the modern era, the creation of the tribunals that take the crimes of war crimes and crimes against humanity and genocide and put it in their statute. So the very first tribunal that is a successor to Nuremberg is the International Criminal Tribunal for the former Yugoslavia that was started in 1993, and the International Criminal Tribunal for Rwanda. Like Nuremberg, they are both ad hoc tribunals. There's a start date and a beginning date. It talks about it covers certain territory, and it covers certain years. And they're about to finish their work. And then you have the original dream of Jackson, individuals who are there for the creation of the International Criminal Court. And others today will be talking more about it and the legacy. This is the first prosecutor of the ICC, Carlos Moreno Ocampo, and the current prosecutor, Fatua Bensouda. Now I want to finish with my hero, Ben Ferencz, who was a prosecutor in Nuremberg in one of the subsequent trials conducted by the Americans. And this is a trial of the Einsatzgruppen, the SS generals who were in charge of the mobile killing squads at age 27. This was the very first trial he ever did. He was the chief prosecutor. As Sandra mentioned yesterday, 22 defendants, all found guilty. And at that time, it was considered to be the greatest murder trial in history in terms of these individuals, were the generals who participated in the murder of over 1 million people, Soviet Jews, by the Einsatzgruppen and squad. Ben is the last living Nuremberg prosecutor, age 95, and when the first ICC trial took place, Ben was invited to give a closing argument. So this is Ben Ferenc at the ICC giving the closing arguments in the very first case. Thank you.
I'm really glad you talked about the semicolon.
Well, thank you very much to both of our speakers for taking us back in time and reflecting, sharing your reflections on the legacy of Nuremberg, on the one hand, by focusing on the continuation of legal thinking from the 19th century till Nuremberg and beyond, and also introducing us to the history of military tribunals and the continuation of it that we are still working with today and following developments depending on conflicts. Before I open the floor to all of you to please address questions to our speakers, I would like to ask the two of you to maybe focus slightly more or share with us your understanding. When I was listening to both of you, there are so many points of where you encounter each other's work and actually refer to each other. And one moment that I found really interesting when listening to you were those when you identified the new conventions of law being tied to Nuremberg, both by looking at results of individuals and by looking at results of a collaborative effort to change what we understand as law, as international humanitarian law. And I was wondering if you could draw out a little more from, based on the research that you have done, where you would see the main contribution on the side of individuals engaged, those thinkers, proponents of humanitarianism that you referred to, those involved in these trials, or the international cooperation?
Well, let me say this. Let me begin with an observation. Nuremberg was the last achievement of the Grand Alliance. If I'm thinking of a big frame, a big political frame, there you have the Grand Alliance, which is essentially, let me put it in the vernacular, getting on with the Russians. This was the central political problem of World War II from the Allies' standpoint from June 1941. How do you get along with these, and Churchill knew it more than anyone, these horrible Russians? They were horrible with matters having to do with justice. They were horrible with matters that were anathema to the Americans and the British, namely bloody revolution. And they were anathema in terms of the individual personality of Joseph Stalin. So how do you get on with these bloody Russians? That was their central political problem. And when you look at Nuremberg in 1945, as they're sitting around a table, they're trying to suppress, that is, the Americans are trying to suppress their feelings, their notions, their political background of dealing with those bloody Russians. That's the issue. Okay, what is not widely known is that there might not have been a Nuremberg if the Soviets had not been willing to extend a measure of collaboration. The Soviets, first of all, didn't want anything. They wanted a down and dirty set of trials. And they were experts on down and dirty trials from the 1930s. And the advice that Stalin was getting involved very important advice from the master of this, Andrei Wyszynski. So you have now a number of people. And by the way, Wyszynski kept a sinister involvement through Nuremberg. That is, they were constantly sending him reports, and he was constantly sending orders back. Okay, I don't know if I'm getting to your issue, but you asked about individuals. Okay, let's talk, I'll just close for a moment with the issue that I think bothers a lot of people, namely the minority status of crimes against humanity. It's an afterthought. Let me add to this now that Robert Jackson was extremely nervous about getting into the Lemkin story, the story that preoccupies most people. If you ask people on the street, what was Nuremberg about? They would probably say, oh, that's crimes against humanity and the Holocaust, isn't it? That's what most people think Nuremberg was all about. So why was Jackson so nervous about it? I want to just say a word about that and say something very interesting. His chief ally in making sure that crimes against humanity remained a minority issue, his chief ally was the Russians. It's one of the paradoxes. In part of my paper that I didn't have a chance to talk about, kept for time, was the meeting, the planning meeting in the summer of 1945. So they're sitting there, and someone says, well, you know, we've got to talk about persecution of the Jews. And, you know, if you think in genocide, everyone knows it didn't just start in 1939, right? It has to go back. It has to go back at least to, you know, the advent of Hitler. So let's do it. At which point Jackson, I don't know if he stood up, but he was getting to stand up. He says, if so, I'm out of here. I'm leaving. No more Nuremberg. What did he mean by that? He then says it, and it's in the minutes of the London meeting. He said, you know, we had a lot of problem with minorities in our country. And we don't want to start getting into this. Of course, he had in mind blacks. He had in mind lynching. He had in mind segregation. So Jackson says, I'm sorry, no way are we going to do this. And Trenin, who is the Russian thinker, also a nice Jewish boy, by the way, Trenin says, don't worry. I say, brother, don't worry, brother. None of this is going to be in the trial because we're just going to concentrate on the war. Fast forward to what Michael was saying about the colon, the semicolon, and the comma. This wasn't a small deal. As a matter of fact, the participating powers had to meet together in October 1945 and work out an agreement. They were still in Berlin. They haven't even got to Nuremberg yet. And they worked out an agreement. We're going to go with the comma. Why the comma? Because the comma links everything to the war. And the war, by the way, is the war of 1939. Of early September 1939. The Soviets didn't want later September because they also invaded somebody. It was Hitler's starting the war. And Jackson signed on to that because it was a guarantee that they wouldn't get into the pre-war anti-Semitism, the persecution, the confiscation of Jewish property. None of that stuff would be involved. I'm sorry I've gone off on this theme. You asked about individuals and big picture. That's the one that first and foremost occurs to me.
I would be interested to hear if you agree or want to add something, Michael Bazler.
I feel I need to defend my Soviet heritage here. Since my uncle was in the Red Army and came close to coming into Berlin before he was wounded and sent over to fight against the Japanese. He wore proudly his medals every day, every May 9th. I have to share this. He had two medals of Stalin. One of them, and they were profiles of Stalin. And one Stalin was facing to the right, and the other one Stalin was facing to the left. Do you know why he had 2 Stalin medals? Because he fought on both fronts. He fought on both fronts, right? So I think, cannot minimize the sacrifice and the contribution that the Soviets made to the war itself. I mean, on May 8th, 9th, I always call Ben Ferenc, and I say, Ben, thank you for saving the world. But because Ben is still alive, if my uncle was still alive, I would be calling him and also saying the same thing. I want to turn to something else, and this is, I think, what maybe is the question that you're asking, or the way that I understood it. And the legacy, I think the most important legacy of Nuremberg is we don't just take bad people and shoot them or hang them. We actually do give them a trial, and not a show trial, but a real trial. Really important to remember, not everyone was convicted in Nuremberg. The film yesterday showed this clearly. There were these defendants who were put on trial by the prosecutors and who at the end were found not guilty and walked away free from that tribunal. The judges looked at the evidence and they made the decision. And I think part of what we have, a big part of today, is that legacy. So when Saddam Hussein was captured, he was put on trial. And even though when the Iraqis were putting him on trial, they were, in a sense, trying to emulate Nuremberg. When in Bangladesh today, there's their form of international tribunal for the war going back to the 1970s, they're emulating Nuremberg. And in fact, some of the judgments from Bangladesh, think of country, there it is, mentioning Nuremberg, mentioning genocide. And then, remember when Osama bin Laden was captured? There was articles and discussion. Well, was he killed, and should he not have been captured and brought to trial? We mentioned this. That discussion is there, I think, because of Nuremberg, because the legacy of we have a real trial, we bring out the evidence, it's not something that was recognized before the Allies created the International Military Tribunal.
Thanks a lot. We still have time, so I would like to invite all of you to join in with questions. Please try to keep them short, as I would also ask you to try and keep the answers to the point so that we can introduce as many questions as possible. Yes, please, and maybe you'll introduce yourself very briefly.
I want to ask a question maybe is unfair to historians, because I want to ask you about imagining a future problem. One of the luxuries of Nuremberg is that the notion of a state was fairly clearly well defined of what was a state and what was a state leader. So my question for you is, imagine yourselves being asked to consult on the first trial of ISIS. What are the lessons from Nuremberg with regard to what some people would call a non-state actor such as ISIS?
Over to you.
That's a really good question. I want to say I hope there is a trial like that. I think it's necessary. I don't know whether it'll be a domestic trial or it'll be an international trial, but the possibility is there, and a very real possibility is there, because of what happened in Nuremberg. We could speculate that those individuals could be captured and could be sent to The Hague to try before the ICC. They could be tried in Iraq. Iraq very much is working on developing its legal system and has a long tradition of having before Saddam, of having a judiciary. The first code was the code that came from that part of the world. So all those things are possible. Obviously, what we don't want to have is impunity and those individuals being put on trial. Now, the question, maybe this is not your question, but it's one that raises in my mind, is that are these, ISIS leaders, are they worried because, we're going to be put on trial and therefore we should not be doing the acts we're doing? I don't think so. I think the ideology and the messianic ideology, which they have, really trumps all that. But ultimately, there is that sense of retribution, the sense of justice that we know that no matter how much long afterwards, these individuals will be tried.
I want to, it took me a moment to think about your question, and I agree it's not only a good question, it's a very difficult question. But let me tell you why I think it's especially difficult with reference to Nuremberg, thinking about Nuremberg. Nuremberg was something the Allies agreed to late in the game. The British were very nervous about a Nuremberg trial and came around to the idea in April 1945. Why did it take so long? It took them so long because they feared that Hitler would still be alive, Goebbels would still be alive, Himmler would still be alive, and they would have to face these guys in court. The last time Hitler had been in court was in the 1920s, and he managed to turn it to good effect, to his own effect. And even when he was put into prison, well, that's when he wrote Mein Kampf. So they were very worried. They were relieved, enormously relieved to hear, we don't have to deal with Hitler. We don't have to deal with Goebbels, the master propagandist. We don't have to deal with Himmler. And so it became an easier thing for them to swallow. What does this call to mind? When you saw the film, I don't know if you saw the film yesterday evening, but when you see these films, one of the extraordinary things about Nuremberg is that the defendants basically accept the paradigm, right? Saddam would have been in his pajamas, going crazy, making noise and so on, disrupting the proceedings and so forth. These guys, they stood up when the judges came in, they sat down, they addressed the court, they basically behaved themselves. A little bit not was Goering, and they had to separate Goering at mealtime from the others because he was stirring them up. But basically, they allowed the proceedings to proceed, and they lent a kind of odd, perverse legitimacy to the proceedings. ISIS, forget about it. They recognize nobody. And so what kind of proceedings are there going to be, if these guys ever come to trial? You see, my friend Lawrence Douglas is the master at teaching us about the pedagogic influence of trials. But Lawrence, you never deal with someone who completely rejects the whole concept, right?
Also, just to respond, the question that you asked, it's not a theoretical question. It's a question. Khalid Sheikh Mohammed, the 9/11 mastermind, is presently facing charges before a military commission in Guantanamo Bay. So it's not as if this is a theoretical question. And a lot of the issues that have to be answered are questions about what's the proper venue. But it's not as if jurists haven't had to address this already. And we can talk about the wisdom of using a military commission, though of course military commissions are what was used at the time of the end of Second World War as well. And in terms of the pedagogic, you certainly, anytime you stage a trial with these kinds of world historical events, history becomes contested, and defendants have an opportunity to respond. And Khalid Sheikh Mohammed has, I don't know if you followed what's been going on in Guantanamo, but he has certainly made an effort to kind of turn the thing into an ideological show trial.
Please go ahead.
I have a question about the comma.
Jenna.
Hi. I said I have a question about the comma. I said it pretty loudly, so I'm sure people heard. But I'm curious about the legal foundation of the Nuremberg laws as making the charges against the Nazis at Nuremberg more difficult, because from 1933, to 1939, there was a system of law that the Nazis had set in place to build a legal foundation for what was to come. And certainly there's the poetic justice of the Nuremberg trials being held where the Nuremberg laws had been drafted and passed, but I'm curious about what role there was and any concerns about those laws actually making these new charges harder to prove because they did form, until at least 1939, some form of legal foundation, or arguably some form of legal foundation, and perhaps the Allies didn't want to hand that defense over to the defendants. They didn't want to bring that legal basis into the courtroom. I'm just curious what kind of effect that might have had on the proceedings at all.
May I just ask you to add who you are, and then I'm going to collect a second question because we still have a few more to add.
Thank you. I'm Jenna Loeb. I'm a law student here at UC Berkeley.
And you were the next, yes.
Thank you. I'm Laurel Fletcher, and I teach at the law school here. So I had a question about Professor Marrus's your thesis about IHL and Nuremberg. And so I would agree with you. I thought your argument was very persuasive in terms of laws and customs of war being IHL absolutely necessary for Nuremberg. My question, or invite you to reflect on this, is sort of course IHL and Nuremberg serve states. And I would say that international criminal law, ICL, also serves states. And in fact, to put it more provocatively, isn't Nuremberg in some ways the best distraction that we've created in the modern era to allow states to essentially sacrifice the political liabilities to preserve state sovereignty, and that what we think of as hard law and rule of law applying to individuals who are essentially no more essential to the state apparatus and its continuity, and that all of the really important long-term issues like reparations remain in a political and negotiated domain.
Well, first of all, I know of no rumination on the Nuremberg laws in the lead-up to the Nuremberg trial. Nuremberg was chosen, by the way, against the wishes of the Soviets, who wanted the trial in Berlin, where they were going to be one of the four-party occupying powers, but the Soviets didn't insist. One reason they didn't insist is that the Americans had total mastery of all of the logistical problems, and nobody else did. The Americans could deliver simultaneous translations. They could deliver communications. They could even deliver, with some repairs, a courthouse, which was the only building left standing in Nuremberg. And believe me, Nuremberg was flattened. Nuremberg stank when the trial began because of all of the bodies still underneath all of the rubble. But the Americans were able to immediately come in with their huge logistic capacity and set things up. Nuremberg. So people set things up. So people talked about Nuremberg being the heart of Nazism, being the place where they had the Nuremberg rallies and so on. But when they got down to business, they got down to business, so to speak, and didn't linger over that, and the Americans didn't want the pre-war history of Nazi persecution to be on the table. They wanted the war. And so when you get rid of the semicolon, the war becomes the whole point of reference of Article 6, C. Now, that's such an interesting question about IHL, the emphasis on IHL really being a kind of way out. I forget how you put it at the end, but it was interesting. And frankly, I have to think about it. I mean, in a way, well, historians like specifics. And so let me talk about one specific instance in which IHL really, really was on the table at Nuremberg, and the Americans conceded. It has to do with submarines. It's a real old-fashioned war crime. There were two admirals, Dönitz and Raeder, there on trial. And the allegation was that the German Navy broke the rules of law pertaining to submarines. There was even a convention that they had all signed. I think it was 1929. It was submarines and poison gas. And they were alleged to have broken the laws of war with reference to submarines in the Pacific, I believe, but also elsewhere. And the German defendant said, well, wait a second. You did it too. Tu quoque. You did it too. And the Americans said, well, we're not on trial here. And somehow the judges, who, as was correctly said last night, the judges sort of like to be hard on the prosecution sometimes. And they said, let's get an American admiral here. Let's get Chester Nimitz. Oh, my God. And Chester Nimitz testified, and he said, yes, we did it too. So IHL has its problems. You see, basically the Americans said, this isn't a committee of inquiry about World War II. This is about trying you guys. But somehow, morally, this case wasn't so persuasive to the German audience, which was so important for the trial, for the pedagogic part that had to deal with Germany.
I'm seeing that there are still many, many questions. However, we already reached our time for this first panel to close. I would like to give Michael Bazler the opportunity to also very briefly respond still, if there is something to add. And I'm very happy that we're just at the beginning of what is a fascinating program for today. So please, those of you who still have questions in mind, keep them for the later panels and also the coffee breaks, where you have the opportunity to continue the conversations with our two speakers. Michael Bazler.
You know, I'm going to yield my time. I think this has been really valuable, and I think there's so much more to go. So let's continue with it.
Okay, thank you very much. Thank you all, and thank you.
Okay.